Hello, this is Matt on the Moon Lambeau channel. Attorney John Deaton has said that it looks like he's going to have to sue the SEC. Now, just to be clear, he is currently representing over 68,000 XRP holders throughout the entire world, but that's as a third party in the SEC versus Ripple case. So, to be clear, it's not that he's explicitly suing the SEC, who is looking for permission, and he was granted a year ago, permission to participate in the SEC versus Ripple lawsuit. But now, something stemming back from a FOIA request last year has resulted in Attorney Deaton saying, well, looks like I'm going to have to sue him. You won't be surprised, but man, these people at the SEC are just the freaking worst. So I want to share with you some of the specifics on that. Also, you guys remember the disaster that is Voyager, correct? Voyager is a cryptocurrency exchange. Apparently, they also offered interest to their customers. It kind of sounded like what Celsius was doing. But we found out today that they have filed for Chapter 11 bankruptcy protection. And wait till I share with you specifically the tremendous risks that they took that resulted in their cryptocurrency exchange needing to file for that. And also, I want to share with you how a lot of their, unfortunately, their customers, I think, were tricked into thinking that they had monetary protections that they don't actually have. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so just a few hours ago, Attorney Deaton shared the following on Twitter. Looks like I have to sue the SEC over my FOIA request for Hinman's calendar. Initially, the SEC argued his calendar was created only for his personal convenience and did not constitute an agency record. Can you believe such nonsense? Like nobody else utilized his calendar? And then he shared this screen grab dating back to September 14th of last year. So this has been going on for some time, but it's still not completely resolved. And it's at a point now where, understandably, Attorney Deaton seems to think that it's just gone on substantially too far, and it's probably finally time to take action. But here's the letter to Attorney Deaton, and it reads in part, I'll just read the first sentence. Please note that any calendars that may exist were created by staff for their personal use and convenience. And so there you go. That was the initial argument. Don't have to hand it over. It's just a calendar for personal use, which is absurd because, of course, of course, if you're working at the SEC, you have to coordinate schedules with your coworkers, as is evidenced in the very next tweet Attorney Deaton shared, where he wrote the following. I appealed this absurd finding, arguing that other agency employees would have relied on his calendar to conduct agency business. We have proof, thanks to Empower Oversight suing the SEC. Notice how Hinman refers the ethics chief to his calendar in order to schedule a meeting. And here's what he shared. So I think it was, I think he accidentally got it backwards, unless I'm missing something, which is possible. If I'm missing something, you guys tell me in the comment section below. But it looks like it was actually an ethics staff member sending email to Hinman, not the other way around, who said, my Outlook is up to date if you want to schedule something. But again, it doesn't matter. Like, this is commonplace. And so the reason that we even have that email is because of Empower Oversight. They filed a FOIA request, which is Freedom of Information Act, and they did get documents. And the purpose of that, it's a thing we do in the United States here, and it's for the purpose of transparency. So we know it's very clear, and this isn't a shocker to anybody, people at the SEC would share their calendars with one another. And then Attorney Deaton wrote the following. The Office of General Counsel finally agreed that the calendar was, in fact, an agency record and remanded the appeal for further action. That was December 2021. On March 1st, 2022, an SEC FOIA specialist informed my office that she was still consulting with other SEC staff. So think about this. The nonsense claim was made in September of last year. Then in December, they agreed that Attorney Deaton was right. Then as of March, months after that, there's still no resolution on this. So they've acknowledged that this is indeed official agency record, not some sort of private thing that the public shouldn't have. But they still haven't moved forward on it. You know, it's just, this is disgusting. It's ruining the idea of transparency, which they're legally required to ensure occurs. It's rather repulsive stuff. And then, on top of this, you get into, I'm not going to play this clip. It goes on for a couple minutes. It's got Bitcoin maximalist Anthony Pompliano, as well as Kevin O'Leary of Shark Tank fame. Now, certainly nothing personal against Mr. O'Leary, but I'm with Attorney Deaton on this one. He wasn't specifically talking about Attorney Deaton, but Mr. O'Leary here of Shark Tank fame thinks that it doesn't make sense pretty much no matter what to go after the SEC because they basically have unlimited funds. So that's right. The SEC could just be as absurd as they want, get away with whatever, and there's never an instance where in his mind it makes reasonable sense to fight back. And so here's the quote from Kevin O'Leary. Suing the SEC is a really bad idea. They have unlimited resources. The outcome is never good. End quote. Well, not only is that a bad approach to life and it's very wimpy, it's also not true. Mark Cuban fought back, and sure, he and I've covered that case in a fair amount of detail on my channel in a couple different videos, so not to run through the whole thing here, but he was accused of something. He said it was bogus. He could have settled for probably a couple $1 million. If memory serves, it's estimated that he ended up spending, I think about $16 million, and again, he could have settled for a couple million. But to him, it was worth it to clear his name, and he did defeat the SEC in court. So the outcome is never good. That's not a true statement, Mr. O'Leary. And Attorney Deaton had the following to say. I respect Kevin O'Leary. His success speaks for itself, but he is dead wrong with what he said to Anthony Pompliano regarding Grayscale's lawsuit versus the SEC. When a regulator becomes a bully, providing zero clarity, you treat that regulator like any other bully and you punch back. So I think the vast majority of us would probably agree about that. I mean, I'm hazarding a guess, admittedly. Then in a separate tweet on the same topic, Attorney Deaton said, although I disagree with Kevin O'Leary and his opinion, it is never good to sue the SEC. He is 100% correct that once we get smart, appropriate regulation in the space, trillions of dollars will come in. Yeah, that's absolutely correct. And we are waiting for that to occur. But there's all sorts of institutional money that is on the sidelines waiting for sufficient regulatory clarity. And in the United States, it'll be like floodgates ultimately when we get this all settled, but it is indeed taking time. All right, so into this train wreck now. Oh, Voyager. My gosh. Nothing but sympathy for the people that were harmed as a result of this, but I want to show you just how reckless these people were and how they misled people into believing that they had protection that they actually didn't have. Account holders at now bankrupt Voyager Digital Ltd. shouldn't expect to get all their crypto back as the company reorganizes. The crypto brokerage and lender filed for Chapter 11 bankruptcy late Tuesday, renewing unresolved legal questions about how digital assets will interact with U.S. insolvency law. One thing is certain, Voyager doesn't intend to simply give users back their Bitcoin, Ether, and other assets stored on the platform. The company's plan to exit bankruptcy plainly says it expects account holders to be impaired by the Chapter 11 process, meaning they won't be getting back exactly what they're owed. Folks, this is why I keep saying, and I keep warning, and I will continue to do so, that phrase, not your keys, not your crypto, well, here's a real-world example of why that matters. Unless you're immediately going to be using crypto for buying, selling, trading, if you're one of those types, it just doesn't make any damn sense on the planet to keep crypto on any exchange, no matter how they're perceived to be trustworthy, no matter how big they are. Using them as a long-term, any exchange as a long-term storage solution is just dangerous. Just self-custody is the way to go. Otherwise, crap like this can happen. And look at how much money is actually owed, and look at what they did, because check this out. This is amazing what they did. Piece reads as follows. Voyager doesn't keep user assets in designated wallets for each customer. It instead mixes deposited crypto into asset-specific pots, like ones for Bitcoin and Ether, according to court papers. The company has about $1.3 billion of crypto assets on its platform, it said in the statement. Now, Voyager also, and this is the terrible part if you're a customer, Voyager also lends deposits to third parties to pay interest to customers, a dynamic that users agree to when they sign up for the platform, Chief Executive Officer Stephen Ehrlich said in sworn bankruptcy papers. So think about this. Like, you're earning interest, and of course all you have to do is give up your keys and expose yourself to tremendous risk, but you're earning interest in theory on the platform. But what's being created here? Like, how is it that you're earning interest on an asset that's just sitting there? Well, the answer is the assets, your assets, which you gave to them, they're loaned out to other firms, and then those other firms make risky bets, hoping to make good trades, and then when markets tank, a little bit of liquidation happens. If you look on your screen right now, you can see what was owed to Voyager. And the one that put them in the coffin 6 feet under was this one right here. This loan to Three Arrows Capital, $654 million, with an M, $654 million loaned out to Three Arrows Capital, which went bankrupt, you may recall. So Three Arrows Capital, not going to be giving that money back. And the people at Voyager knew, they had to have known, of course, that if they didn't get this repaid from Three Arrows Capital, that they would cease to be an exchange, but they made the risky loan anyway to earn a percentage. And the borrow rate is cited on the screen here, is 3 to 10%. Oh man, this is just wild stuff here. And on this topic, a shout out to a gentleman who goes by the name Pompous Maxi on Twitter, who tagged me, along with another individual, and wrote, "Wow, always good to read the fine print. These MFs promoted FDIC insurance as a reason to trust them," and shared this screen grab from Voyager, which says, "Your US dollars are FDIC insured, secured by our banking partner, up to $250,000. That's more than a little bit misleading. Here's their actual bank, Metropolitan Commercial Bank. And as it turns out, it's only partly true. The $250,000, yes, you're protected, but that's only if Metropolitan Commercial Bank goes under, not if Voyager goes under. That's incredibly misleading. So people, if you thought you had $250,000 protection there because you're using Voyager's platform, no, they were just misleading you. You absolutely did not have that protection. So they misled you, then they loaned out your crypto recklessly to other individuals, knowing that if they weren't paid back, they'd go out of business. Holy freaking hell. And now they're in Chapter 11, so they're protected for now. Oh my gosh. I'll keep you updated as things unfold, but that's where we're at right now. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.